In a shocking case out of New York, a legal gun owner actually had his charges dropped. But in the lawsuit that came after, the judge ruled that the wrongful arrest was an innocent mistake on the NYPD's part, ruling it's perfectly fine to be ignorant of the law if you work in law enforcement. Hello everyone and welcome back to the channel. Today I have a case of the NYPD wrongfully arresting a legal gun owner on charges of illegal possession of a firearm and ammunition, confiscating his firearms and suspending his license, and the gun owner somehow getting the charges dropped and actually even eventually getting his property back. Though the cops won't face any disciplinary actions from the court, even though they were ignorant of the state's own laws and turned to Google instead of their superior officer to decide to arrest the guy. And honestly, though the case is pretty clear-cut to you and me, it's amazing that this guy even got his charges dropped, seeing the number of folks who get hit with gun charges, even if they have a license in another state and are just passing through, and routinely get told that ignorance of the law in a state or city they don't even live in, New York or New York City, is no excuse. Just look at all the people who pass through LaGuardia Airport, for example, and get arrested because they didn't know they needed a New York City specific permit to declare their firearm on a trip. What are they told? Ignorance of the law is no excuse. Again, apparently, unless you are responsible for enforcing those laws. But before I jump into this case, this video is brought to you by the Attorneys on Retainer program from the Attorneys for Freedom law firm and their newest addition to the program. You already know that they cover self-defense cases and criminal charges if you get charged for the defensive action, we'll call it. Now, if you get charged with a regulatory crime, like having a gun in a gun-free zone, for example, AOR is there for you for that too. This covers all weapons, from firearms to knives to any defensive tool used in legitimate self-defense. If you are already an AOR member, you don't have to do anything new to get the benefit. If you're not a member, then become one today by going to my link down in the description and using code LibertyDoll for $25 off your individual sign-up fee. Okay, so this case was a lawsuit brought by Army veteran, Purple Heart recipient, and legal gun owner Rafiq Khan, who lives in Queens and did 3 tours in Afghanistan. He has both a concealed carry permit and a premises permit, working as an armed federal environment protection specialist assigned to Fort Wadsworth on Staten Island. He was pulled over in November 2023 while driving his BMW home after celebrating his mother's 70th birthday. He says at the time that he wasn't given a reason for the traffic stop, and the original complaint doesn't have a reason either. When stopped, he informed officers Besson and Nicholson of the NYPD that he had a firearm in his glove box, had his license, and that his registration was in the sun visor of the car. According to the lawsuit, he was ordered out of the car without explanation. The officers conducted a search and arrested him without giving him his Miranda warnings. They made him surrender his firearm on the spot. Officers questioned him on how he got his IDs and documents, presumably assuming they were fake, and even arrested his cousin and friend, who were both also in the car. Now, we know from other cases in other states that most of the time, cops are not supposed to just automatically assume a license is fake or doctored or illegitimate, and it's basically supposed to count as a valid license so long as it's not expired. And even if it is expired, if you have like an email or something saying, hey, I applied to renew it, that is also supposed to count. All of that was just skipped right over. Khan claims that this is race-based, and it could be, but it could also just be that the NYPD sucks. Maybe even it's a little bit of both. He was detained for 34 hours, was denied access to legal counsel and phone calls, and says that he wasn't even told of the charges against him until the next morning when he met with a Legal Aid Society attorney. He was released once an attorney provided proof of his gun licenses. Still, the police made him surrender his firearms and suspended his licenses. At his next hearing, he proved his paperwork and licenses were valid. The DA verified it, and his charges were dropped in February 2024. His guns weren't returned until April that year, supposedly after the NYPD had defaced them by engraving numbers in the mags and the frames. Now, to my understanding, the NYPD actually tried to stop discovery from happening in this lawsuit, saying, well, his case was dismissed, like the charges were dismissed, and it was an innocent mistake, so his lawsuit should also be dismissed, so we don't need to provide the courts with any information. All of this is occurring in Rafiq Khan versus New York City et al., which names everyone from Eric Adams to several named police officers, who I mentioned already, plus more of them, and even a few John and Jane Doe officers. It is a long laundry list. Khan sued on the grounds of false imprisonment and false arrest, discrimination, and violation of his Second Amendment rights. As part of the suit, he also said the officers had no probable cause to stop him, search his car, or arrest him. Well, now that we have U.S. District Judge Brian Cogan's opinion, we know more about what happened because, by the way, New York very much restricts who can see any of the court documents going through their court system. So this is what we now know. Shortly after receiving his concealed carry license, plaintiff's family came to New York to celebrate what would have been his late mother's 70th birthday. At one point, the group left plaintiff's residence in plaintiff's car, a blue BMW, to attend a surprise planned by plaintiff's cousin. Plaintiff took his firearm and his concealed carry license with him. When plaintiff parked, plaintiff realized that the surprise was a meal at an eatery in his old neighborhood. Plaintiff was cognizant that even licensed firearms are not permitted in eateries that serve alcohol. So when plaintiff first approached the eatery, still armed, he asked the employee at the entrance whether alcohol was served. After learning that it was, plaintiff returned to his car and placed the gun inside and went back to join his family. So, by all accounts, Mr. Khan here followed the law and did the right thing. At some point, the Police Intelligence Division was tipped off that someone matching plaintiff's description was in possession of a firearm, tried to enter the eatery, and then put the firearm in the glove box of a blue BMW. Shortly thereafter, Officer Hughes was briefed on the situation and left with Officers Besson and Nicholson to investigate. The officers located the blue BMW, ran the license plate, and determined that the car belonged to plaintiff. The officers then searched plaintiff's name through various databases and learned that plaintiff had a business carry firearm license. Before New York State Rifle and Pistol Association v. Bruin, New York used the words business carry to describe a license permitting the holder to conceal a firearm because, at that time, anyone seeking a license to carry a concealed firearm had to show cause, such as a business reason, for doing so. Post-Bruin, i.e. at the time the officers identified plaintiff's firearm license in the database, New York changed the term to a concealed carry firearm license. Nonetheless, licenses that were once listed as business carry in police databases, such as plaintiff's, were not automatically updated. Apparently, none of the officers on the scene, and I remind you, ladies and gentlemen, there were 3, knew what a business carry firearm license was, even though Bruin was not that long ago. After turning to the internet, the officers had even less clarity. Even so, the officers continued watching and eventually saw plaintiff and 2 others leave the eatery and sit in the blue BMW for about half an hour. After plaintiff began to drive away, the officers initiated a traffic stop. So, these officers didn't know the law, didn't know the changes that came after Bruin, even though, again, Bruin was not that long ago, and instead of calling into the department and asking around, they turned to Google. Google was apparently less than helpful because this is New York we're talking about, and still, after a half hour during which they could have easily called a supervisor and chose not to, they just figured, hey, let's arrest the guy, because we're the NYPD. Next, officers approached the car. Khan told them he had a firearm. They immediately took it and took his licenses. Officer Besson, probably confused by what a business carry license was, and even more confused that plaintiff's physical license didn't match what he saw in the database, arrested plaintiff, purportedly for violating New York Penal Law 400, licensing and other provisions relating to firearms. The next day, plaintiff was arraigned on various state and city firearms offenses. A day later, Officer Astorita from the Police Licensing Division began investigating plaintiff's arrest. Astorita notified notified plaintiff that, by law, he was required to surrender his other firearms and his licenses would be temporarily suspended pending the resolution of the investigation. So, instead of going to the other cops and saying, hey, you arrested someone you shouldn't have, and informing them of the law, or any of that, this guy went and told Khan he had to give up his guns and have his licenses suspended, even after learning that he was, in fact, properly licensed. In fact, earlier in the suit, these cops still apparently didn't know the law because one of their attorneys even argued that Khan was only allowed to carry at work, which is not what the NYPD database says. About 3 months after his arrest, all of the criminal charges were dismissed, and plaintiff notified Astorita about the dismissal. About 2 weeks thereafter, Astorita closed a licensing division investigation, and plaintiff was notified that his licenses would be continued, i.e. the licenses would remain valid. Kogan, after laying this all out and pointing out the myriad of ways that the NYPD didn't do their due diligence or therefore their job, says that since Khan matched the description of the tip they got and the gun was stored in the glove box and not a properly locked container, that was probable cause to stop and arrest him, even though ultimately violating the safe storage law isn't even what he was charged with. And again, even though they arrested him with valid licenses, assumed that those licenses were doctored or faked, and didn't contact superior officers, instead consulted Google for whether or not to arrest this guy, and no one else at the NYPD thought to look into any of this, and then when one guy finally did and figured it out, he didn't even correct anybody. He just went and took the guy's guns and licenses. But back to the probable cause section, because I went a little off there. Upon the officer's arrival at that location, the officers observed a blue BMW parked near a fire hydrant. Eventually, the officers saw a plaintiff, who is 5 feet 11 inches tall and was wearing black pants, a black and white shirt, gold chain, and had hair long enough to pull into a ponytail, get into the blue BMW. In other words, the officers independently corroborated every piece of information that the informant gave. This is a reference to an earlier paragraph about the description that the informant gave, except for the location of the firearm inside the vehicle. That is sufficient to establish probable cause to believe the uncorroborated information, i.e. that plaintiff stored his firearm in his glove box in violation of New York Penal Law 265.452.2. The officer therefore had probable cause to arrest the plaintiff. He says, according to the Supreme Court, they only need probable cause to arrest him on something, not the thing he was actually arrested and charged for, and that not knowing the law, not calling a supervisor, and then the licensing guy not telling the arresting officers that they'd done f***ed up, was all a series of innocent mistakes. So somehow these innocent mistakes and the fact that this guy matched a tip that they got about someone with a gun putting it in their car negates the fact they ignored his legal, valid 2 New York gun licenses and locked this guy up and took his property and suspended his licenses and affected his work. The description and innocent mistakes somehow negate all of that. Therefore, says the judge, it was not false arrest, and because there was no false arrest, Khan can't claim his rights were violated. It is, all in all, a pretty ridiculous, though sadly unsurprising opinion. Khan did eventually get his firearms back for what it's worth, but according to his attorney and court documents, it took another lawsuit and 2 court orders. Also, sadly, unsurprising. Meanwhile, Khan gets nothing for his lost time, his defaced and damaged property, his issues at work, and these cops get to just keep on doing the same thing without any accountability. All right, ladies and gentlemen, that is it for this video. You guys know the drill for all of the algorithm things. Please do them. And as always, thanks for tuning in. Stay safe out there. Get out of New York. And happy shooting.